In this episode, we will be discussing Arizona Tenant Early Lease Termination. The Arizona Residential Landlord and Tenant Act outlines the following situations as being lawful reasons for a tenant to terminate his or her tenancy before the end of the lease term. Domestic violence or sexual assault. A tenant may terminate a rental agreement pursuant to this section if the tenant provides to the landlord written notice that the tenant is the victim of domestic violence as defined under the law in Section 13-3601, or was the victim in the tenant's dwelling of sexual assault pursuant to Section 13-1406. The tenant's rights and obligations under the rental agreement are terminated, and the tenant shall vacate the dwelling and avoid liability for future rent and shall not incur early termination penalties or fees if the tenant provides to the landlord a written notice requesting release from the rental agreement with a mutually agreed on release date within the next 30 days, accompanied by any one of the following: a copy of any protective order issued pursuant to Section 13-3602 to a tenant who is a victim of domestic violence or sexual assault. A landlord may also request a receipt or signed statement that the order of protection has been submitted to an authorized officer of a court for service. Or the tenant may provide a copy of a written report from a law enforcement agency that states the tenant notified them that the tenant was a victim of domestic violence or sexual assault. It is important to note a landlord may request from the victim the name and address of the person named in an order of protection or a departmental report pursuant to this subsection in writing if known by the victim. 30 days prior to termination notice. The tenant may terminate the rental agreement pursuant to this section only if the actions, events, or circumstances that resulted in the tenant being a victim of domestic violence or sexual assault occurred within the 30-day period immediately preceding the written notice of termination to the landlord unless waived by the landlord. Rent. If the tenant terminates the rental agreement as prescribed by this section, and if the tenant is solely or jointly liable on the rental agreement, the tenant is liable only for rent owed or paid through the date of the lease termination, plus any previous obligations outstanding on that date. The amount due from the tenant shall be paid to the landlord on or before the date the tenant vacates the dwelling. Prepaid rent. If the tenant has prepaid rent that would apply for the month in which the lease is terminated, the landlord may retain the prepaid rent and no refund is due to the tenant. Security deposit. If the tenant has paid a security deposit, the landlord shall not withhold the security deposit for the early termination of the lease if the tenant meets the requirements prescribed by the subsection of domestic violence or sexual assault, but may withhold the security deposit for payment of damages that the landlord suffered by reason of the tenant's non-compliance with the laws found under our other video titled Arizona Tenant to Maintain Fit Premises. New locks. A tenant who is a victim of domestic violence or sexual assault may require the landlord to install a new lock to the tenant's dwelling if the tenant pays for the cost of installing the new lock. A landlord may comply with this requirement by doing either of the following: rekeying the lock if the lock is in good working condition, or replacing the entire locking mechanism with a locking mechanism of equal or better quality than the lock being replaced. It is important to note, a landlord who installs a new lock at the tenant's request may retain a copy of the key that opens the new lock. Notwithstanding any provision in the rental agreement, the landlord may refuse to provide a key that opens the new lock to the person named in an order of protection or a departmental report pursuant to the subsection titled Domestic Violence or Sexual Assault. Refusing access to the accused. A landlord shall refuse to provide access to the dwelling to reclaim property to any tenant named in an order of protection or a departmental report pursuant to the subsection Domestic Violence or Sexual Assault who has been served with an order of protection naming that tenant as the defendant and the landlord has received a copy of the order of protection, unless a law enforcement officer escorts the tenant into and out of the dwelling. Terminating under a false report. A tenant who terminates a lease pursuant to this section and who is convicted of falsely filing a departmental report or order of protection for domestic violence or sexual assault is liable to the landlord for treble damages for premature termination of the lease. Civil liability of the accused. A person named in an order of protection or a departmental report pursuant to the subsection Domestic Violence or Sexual Assault who provokes an early termination under this section is deemed to have interfered with the residential rental agreement between the landlord and tenant, regardless of whether the person is a party to the rental agreement, and may be civilly liable for economic losses incurred by a landlord due to the early termination. This civil liability includes unpaid rent, early termination fees, costs to repair damage to the premises, and any reductions or waivers of rent previously granted to the tenant who was the victim of domestic violence or sexual assault. Multiple tenants. If there are multiple tenants who are parties to a rental agreement that has been terminated under this section, the tenancy for those tenants also terminates. The tenants who are not the victims of domestic violence or sexual assault, excluding the person named in an order of protection or a departmental report that caused the termination of the lease pursuant to this section, may be released from any financial obligations due under the previously existing rental agreement, and the remaining tenants may be allowed to enter into a new lease with the landlord if all current application requirements are met. Entire property protected. An emergency order of protection or a protective order that is issued to a resident of a rental property automatically applies to the entire residential rental property in which the tenant has a rental agreement. For additional laws and articles, visit AmericanLandlord.com.